Hi, and welcome to All Things Divorce Podcast. I'm Launi Sheldon, the host of All Things Divorce Podcast. And today we have Steve Sheldon. He's going to talk about the benefits of going to mediation versus going through litigation. In case you didn't notice the names, Steve Sheldon has the same last name as me, and that is because he's my husband. So as usual, this podcast is not meant to give specific advice for your specific issues and is for entertainment purposes only. Listening to this podcast does not create an attorney-client privilege, and although the information discussed in this podcast may be used in all or most jurisdictions, both Launi and Steve are only licensed to practice in Arizona. So a little bit about Steve. He returned to school on the GI Bill after returning from Vietnam. He graduated from Loyola Law School in Los Angeles and then applied for and was offered a job at a large law firm in Phoenix. Shortly after moving to Phoenix, he also decided to apply for a position as an FBI agent. Steve was accepted and later began work at his first office assignment in Oregon, and then he was later assigned to language school in Monterey, California, and from there he was assigned to a foreign counterintelligence group in Washington, D.C. Steve left the FBI and returned to Phoenix to continue practicing law after returning. Steve also became involved in one of the first Phoenix community mediation training programs, as mediation was really starting to become the preferred alternative to just simply litigating. And he was involved in the program until he became and was appointed a judge for the Maricopa County Superior Court, where he presided over civil and family law cases and criminal. Steve retired from the bench and returned to private practice, where he's been focusing on mediation and discovery master work for the last, he puts few years, but I'm saying several years. So welcome, Steve.
Lonnie, thank you. It's very nice to be here this morning. I know you've been conducting the podcast for a while, and you've had some really great guests on the show. So I appreciate the invitation and look forward to talking to you about why I think, in my experience, mediation is a far better choice than simply litigating a case in court and hoping that the judge sees the case the way you do.
Well, thank you for being here. I know I nagged Steve. He's not huge on being on camera, and so I did have to nag him a little bit to be on here, but I appreciate you being here. So Steve, let's talk about that. Why is mediation, or why is it oftentimes, because I know it can't always be, but why is it oftentimes better, a better alternative to mediate as opposed to litigating?
Lonnie, that's a great question. And just as a little background, you noted that I was one of the first community mediators with the Phoenix program way back, and that kind of dovetailed into being invited onto the I think one of the first subcommittees of our Supreme Court way back when Justice Feldman was pushing and Justice Lackett pushing for more alternative dispute resolution in the courts, and I was on a subcommittee that then Justice Meyerson, or Judge Meyerson, was handling. So I've been involved in the court's emphasis on the ADR programs for quite a long time. So I'm a big believer in it. I will share that I'm probably even a stronger believer in it now that I've left the bench and crossed over into the practice session with fellow family law lawyers, and have had the opportunity to litigate cases in the courtroom. So I'm even a stronger believer now in mediation than I was on the bench. But it clearly saves costs. Litigants have way more control over the potential outcome of their case than if they simply throw it into the judge's lap after the trial's over. It's probably less stressful and frustrating. Trials are stressful, I think, for the lawyers and the litigants. And it certainly is frustrating for the litigants if, after the judge makes a decision, the litigants wonder if the judge was listening to the same case that they tried in front of the judge. So you get more time to discuss the issues. I think the practice in Maricopa County Superior Court for a rather lengthy period of time has been to limit trials to about 3 hours. And oftentimes, I think lawyers would agree that simply is not enough time to give the litigants a fair chance to present sometimes complex and difficult issues to the trial court. So you have way more time to discuss that during a mediation. And I think one of the really great things about mediation is that it gives the parties an opportunity to come up with some solutions that courts are just too busy to entertain, and time limits on trials don't allow the presentation of it. So all of those things, I think, demonstrate the real benefits of mediating rather than litigating a case in front of the judge.
And, I absolutely agree with that. It's not only you get more time, people get to be heard. In court, often they don't get to be heard. And I've had a lot of clients where they just want to talk and talk and talk. And I know you've had a lot of people mediating with you that just want to talk and talk. You are so patient. I have to say, Steve is so patient in his mediations. Every now and then I overhear him because he's got an office in the house, and he's so patient, much more patient than I can be. But it's also so much less formal. And that was one of the things I loved with my clients, was that it was, you don't have to wear a suit necessarily. You're not all dressed up. You can eat, you can drink. If it's online, right, you can eat and you can drink and you can, hang out on your couch with your cat or your dog, and just hang out. I've had clients, that, want to have to that ease. So that's a great point, Steve. So tell me how specifically it can save costs.
Well, I think a lot of litigants, when they get wrapped up in the whole litigation process, find out very quickly what discovery means. And it means that the lawyer and perhaps staff in the lawyer's office are obtaining information from the other side that may eventually be used as evidence in a trial. For example, credit card reports, credit card statements, bank statements, documents relating to property. If you've got business evaluations involved in a case, they're getting accounting data that is being disclosed. They're getting business expert reports. All of that translates into sometimes very significant expense for the litigants before they ever get to trial. And while it might seem counterintuitive to the litigants, it seems that the less time that a lawyer has to present evidence in a trial, the more time they've got to spend getting prepared so that they can be very efficient and quick in presenting the evidence at a very short trial, which generally requires a lot more time being put into the development of exhibits, preparing clients, preparing the lawyer's examination of witnesses, and all that can turn into very enormous costs for the litigant.
And that is also a great point, because when I remember, going to trial, and sometimes, especially if it gets continued and continued, you've got this time span, and I've had to re-prepare myself for trials for clients. And do I want to charge them for that? No, but I have to. I'm putting in a lot of time and effort for something that's not the client's fault necessarily. Might just be a court thing. And also the cases are so drawn out, right? I mean, sometimes you're ready to set it for trial and you can't get a trial for 6 or 8 months. And then that's another issue that causes an increase in funds. I think that, even if you're done with everything and you're just waiting for the trial, there's still the communication, the bickering, the problems with parenting time, the fighting that can also increase costs.
Yeah, I think those are all great points, Launi, and certainly the continuances can happen for a whole variety of reasons. We certainly have seen that over the past few years with the pandemic, the flu season. I mean, you get even lawyers with the best intentions of trying to get to trial could be sick. Their client could be sick. Deaths in families occur. So when you do have that issue of getting prepared and spending a lot of time for the trial, and all of a sudden it's vacated, that's kind of a hidden cost in this whole litigation process that again plays back into that frustration with litigants with the whole legal system, because they're just spending a lot of money and getting nowhere.
Yeah, and if it's taking 2 years, it's going to be a lot of money for sure. So one of the things that you said was that you have more control over the outcome. What kinds of things will you have more control over if you're mediating?
Well, one example, well, two examples come to mind, one of which I'd like to spend some time talking about. I know we have some limited time, so I'm not going to go into both of these in depth, but with respect to the marital residence, if there is one involved in the marriage, and also business evaluations, there is far more control over the litigants in a mediation than if they end up going to trial. As an example, I would just point out, as I do often in mediations to litigants, look, if you go to trial and you've got expert opinions or you've got evidence on the value of the residence, you have evidence on the value of the business, and you probably have value A and you have value B. Well, if you go to trial, a judge has to rely on evidence at a trial to make a decision. And judges have been reversed on appeal when they've tried to do what they thought was a fair, equitable thing, add the two A and B together, divide by 2 and come up with a fair number. The problem with that is there's no evidence, assuming there's no evidence in that regard in front of the trial court, a judge would get reversed because there's simply no evidence to support that decision. So the judge has to choose A or B. Now, in a mediation, you may have a situation where the parties don't agree on the value of a home, for example, which is a frequent issue of contention in mediations. One party believes it's valued at A, the other party thinks it's valued at B. And in a rising or falling real estate market, those can become real issues of contention. Whether or not there's evidence that is equated from both sides. By that I mean, do they both have appraisals, or does one have appraisal and the other one says, look, Zillow says it's worth X, which does happen. So in a mediation, you can start negotiating. Well, I don't think it's A, I don't think it's B. Let's see if we can meet somewhere between those two values that satisfy both of our desires to settle the case without going on and presenting this to the court. So in that regard, you have much more flexibility to come up with a creative solution on value. And oftentimes there's an urge to get to mediation to save what we've already talked about, the discovery costs. And litigants will go or try to go very early. And sometimes they show up and try to litigate or mediate the value of the residence, and neither one of them have very good information. They're both maybe relying on Zillow, or someone says, I talked to a real estate agent and they said it's worth X. You can imagine that doesn't seem to carry the day with the other side.
Well, right now, specifically with the changes in real estate values. So abruptly, are they going up? Are they going down? I mean, right now they're clearly going down, but yeah, you could have a value from 6 months ago that may not be now.
No, pardon me for interrupting, but you're exactly right. And that's what happens. And the rising interest rates are decreasing the demand for properties, which is affecting the supply. And as that happens, even basic economics that we all remember from school tells us that that's probably going to have an effect on price. So we get into some real debates over that. Still, within the last month or so, I've had an issue come up about that. Now, one of the solutions that we had in that case, if they couldn't compromise on a value for the sake of simply mediating and saving discovery costs and lawyer costs, was trying to work out a procedure that they could agree on to arrive at a value that both of them would live with. And we agreed that they would mutually agree on an appraiser, but each of them reserved the right, if they didn't agree with that number, to then retain and pay for their own appraisal from a certified appraiser. And then they would look at those two values, and if they were within 10% of each other, they would add them together and take the average of them, and that would be the value of the home to then deduct the costs of the encumbrances out of and then split the equity.
And the judge can't do that in litigation. That's what you said, right? That's the one thing that they can't do.
Correct. They cannot do that. So that does gives you the flexibility to do that. And another issue that can come up in that context when you figure out the value is, what do you back out of the value to come up with the amount that should be divided between the parties? Now, all this assumes one of the persons or one of the litigants wants to keep the house. If somebody doesn't, neither one of them want to keep the house, they're going to put it on the market and sell it. Then you just have to come up with a realtor and a value that you're going to list it at. But assume that the parties agree on a value, one of them wants to keep it, then you have to decide what gets backed out. Obviously, HELOCs are a big deal, first and second mortgages, all the liens. But then the issue can sometimes come up, well, how about the cost of selling the house? We're getting the benefit of that, so we should share that. And that's oftentimes the position that people will take. Because if you go to trial in front of a judge, not only will the judge choose value A or B, but the case law is such that the judge cannot back out costs of sale unless there's an imminent planned sale of the home. And the case law is very clear on that. And lawyers, all the lawyers I've run across in mediation are very well aware of the case. And if somebody wants to back out the sales cost, the first thing they say is, you can't do that because you're keeping the house. Well, you can do that. It's part of the whole negotiation process. And again, it gives you a little piece of the mediation to work with to see if you can come to a resolution rather than simply going to trial. Obviously, if you go to trial, no one could disagree that the judge does not have the authority to do it, but you certainly do in a mediation to settle the case.
Yeah, that's that's so important because you'd have to hire an expert, you'd have to hire an appraiser possibly, or two appraisers. Same with business valuations. You'd have to hire those experts to come in and talk to the judge about why one person's value is better than the other person's value. And that, again, is so expensive and really time consuming. So if you've got a 3-hour trial, you're going to need to push for more time than that if you've got any experts, because when it's a 3-hour trial, it's 3 hours for everybody. So you get half of that minus whatever the judge takes. So talk to me about some of the benefits that you get out of mediation with the debt.
Well, again, those are numbers. I mean, there's very little wiggle room to argue about there isn't debt or there is debt. You can certainly argue about whether it was waste or whether it was premarital debt, such as a student loan, that equitably should be allocated to one of the parties. But where some really frustration, I think, for litigants can occur is during a mediation, you're trying to allocate assets and debt. And if you don't have a mutual understanding and agreement between the lawyers or the litigants on what debt exists at or near the date of service, it can really cause you to waste and spend a lot of time in mediation. So your lawyer's sitting there and you're paying your lawyer to try to negotiate a resolution of debt, and it's taking more time than it should, which means you're spending a lot of money on that. So I think it is generally very helpful for litigants, if debt is going to be an issue during mediation, to use a spreadsheet of some type to show the debt that existed, in your view, at or near the time of service. If you want to drop some footnotes or asterisks to explain that I think a large part of that debt should be allocated to the other party because it was pre-existed the marital estate, or if we can't prove its waste, it's pretty close to it, and we can make an equitable argument to the judge that this person went out and spent this money at the casino. Certainly drugs and prostitutes and that kind of thing are almost a slam dunk on waste. But there are a lot of areas in between where litigants will argue, well, look at all the money that came out of this ATM and I don't know where it went. There was $400 here and $300. If you look at the case law, that's going to be a pretty tough hurdle to get over. But it's something that you should be able to put on a spreadsheet to say, look, if we go to trial, we're going to argue that the judge in equity should not allocate half of all this debt because you spent all this on doing X, Y, and Z. Even if we can't prove waste as an equitable argument, we're going to ask the judge to take it into consideration under Toth or other case law. So it can help, but don't get sidetracked on arguing waste if it doesn't really seem to fit the bill to make the other side concerned about that, because keep in mind the psychological aspect of that when you start arguing waste, how it could put the other party in a defensive position and maybe cause some friction in a mediation that you otherwise don't want to have there.
Well,
So,
and that's another good point with the debt and with the house. If one party's believing that there's too much debt and they want a lower or higher price on the house, in mediation you can sort of mush all those together to come up with a price that somebody wants, a value that somebody needs to move on, where the court can't do that, right? So the court can't go, well, because I'm giving you the house at this value, we're not going to accept any of their numbers.
yeah, that is a great point. And to maybe talk about that just a little bit, my memory is there's a case, the Lee v. Lee case, that takes away from the court the ability to say, look, you guys are going to get $100,000 equity out of the sale of your home. I'm going to order that X amount of that be used to pay off all your debts. The Lee case, I've always interpreted as saying courts can't do that. But parties oftentimes will look, we're going to get, X out of the house. Let's go ahead and pay off these debts out of the house so that everybody walks away with no or very little debt. Another thing you can do is if you can't allocate the debt in a way, for example, that not quite waste issue, but you want somebody to take a disproportionate share of the debt, you can say, look, if we divide the debt, we're just going to get 15,000. But I think you got an extra 5,000. And rather than arguing about that and splitting it now, if you're selling the house, you can say, look, and out of your half of the sale proceeds, let's just kick the can down the road. When you sell the house, you pay the 5,000 out of your share of the proceeds. And oftentimes, if people aren't taking money out of their pocket right then, it can be something that they will at least talk to their lawyer about, hopefully if they have a lawyer, and decide, that's an okay resolution. I'd rather pay that $5,000 down the road, the continued discovery costs and litigation costs. Let's do that. So that's one of those creative things you can do with the equity in the house. Another can happen with the spousal maintenance issues. As most of the attorneys in Maricopa County know, at this point in time, judges have earned a reputation in Maricopa County as not being particularly generous about spousal maintenance. And you can use disproportionate allocation of equity in a home to either reduce or eliminate perhaps spousal maintenance to make it a little more palatable. So if you've got current income at a level that doesn't allow for the payment of a lot of spousal maintenance, you may keep it down at a reduced level, but then also supplement it with some money out of the equity from the home. Again, that's something that a trial judge would not do. So it gives you that flexibility in the area of debt and with spousal maintenance.
Yeah, and I've actually, you and I have talked about this many times, where you will, in prepping for your mediations, you will come up with a number that's like, all right, if one party wants $2,000 a month for 5 years, you come up with this number of just over $100,000, $120,000, I guess. And then you're going, okay, so the spousal maintenance is $120,000. So let's see if we can kind of work that price into it. Again, another thing you can't do in a trial, but that you can absolutely do during litigation. And then the ick factor that the spouse paying spousal maintenance, there's an ick factor sometimes to paying the spousal maintenance, to writing that check every month, that disappears.
Yeah, and that is a great example why you got the flexibility in a mediation. if you've got the issue of spousal maintenance, looking at it from sometimes that global number perspective. Because when you do that, if you get the litigants thinking in terms of that big number, the global number, you can then see if you can satisfy that out of, for example, we were talking about equity in the home, but you can also look at it if one of the parties is older and more concerned about security and retirement. You can talk about maybe translating that into a larger share of the amount of retirement funds that might be available. The lawyers are almost always, without exception, very aware that the present value of money is very different than retirement money. So that's got to be taken into account. And that certainly is a basis for some higgling and haggling between the lawyers sometimes, but that can also be something creatively you can do as far as spousal maintenance, putting it down the road to get it as part of the retirement. A judge would, there's no way a judge would do that, engage in that kind of calculus after the trial's over to allocate funds. At least I've never heard of it. That's the easiest and most simple thing for the judges to do in their 4-minute entries after trial is to divide retirement funds with quadros, and that's it. So this again gives people a lot more flexibility in looking at options in a mediation.
Yeah, one thing that we didn't talk about, and that so I'm going to throw you a little curveball here, is life insurance. Courts can't order a party to allow the other person to be a benefit on life insurance, but you can do that in mediation, correct?
Right. That's a great point. I mean, and it will come up. I mean, if you've got folks that are in their 40s and 50s that are getting divorced, a long-term marriage, there's perhaps significant spousal maintenance that might be awarded over a period of time, and particularly if one of them is not expected to be in great health or has a family history of problems of cancer, heart issues, whatever, assuming they can get an insurance policy or have one already, to make the spouse the beneficiary of that policy to cover the payments for spousal maintenance is a great thing and a great option you've got in mediation. And again, you're absolutely right. A trial judge, at least at this point in time in our state, doesn't have the authority to do that.
Yeah, and that's a good point. You said in our state. We practice in Arizona. I don't know the laws in other states. They might allow the spouse or the life insurance offsets. I think even was it Canada that you and I went to a conference that someone from Canada was selling some kind of like spousal maintenance insurance specifically. They had that website.
Yeah, that's right.
So Canada might have already taken care of that. But even if you've got a life insurance of someone who's much older, and even if they're not paying spousal, they can, in Arizona, you can agree to let them be the beneficiary, but not in court, not in trial, right?
Right. And again, you raise a really good point. Even if spousal maintenance isn't an issue, if it turns out that there is some insurable interest that they can come up with that would satisfy an insurance company's inquiry, they might be able to continue one of the spouses as a beneficiary on a policy. So
let's go through and talk. One of the things that I have always appreciated about mediation, I think, rather than litigation, is the parenting time and decision making. And really, I mean, decision making is hard, right? That's gonna if somebody's got that, if they're digging their heels in, that's a tough one. But parenting time and decision making, you get a lot more control over your schedule, your parenting plan, things like that. Can you talk about that a little bit?
Sure. You raise a great point. And in my experience, that is probably one of the issues that can be the most difficult to try to resolve in a mediation. If there are, ancillary issues that affect a parent's decision, domestic violence, substance abuse, work schedules, all kinds of kind of problems that can come up that will make it very difficult to reach a mediated agreement on parenting time. That's kind of an issue that's going to end up before the court. But assuming that you don't have roadblocks to coming up with an agreement, you're right. It does give the lawyers far more and the parties far more flexibility in coming up with a plan. And again, I suppose you've in other podcasts had folks talk about, and I know you've emphasized it before, how important the pretrial statement is. If you end up going to trial, I would hope that the lawyer, the litigant, has put into their pretrial statement a parenting plan, holiday and vacation plan for the judge.
I think a parenting plan is required now, though I don't think everybody does it.
Yeah, if it's parenting time in accordance with the statutes, that really doesn't help the judge too much. But you can see if you've got a 3-hour trial and you can't spend time arguing about Easter and Halloween and Flag Day, that you've got to have that in your pretrial statement somewhere for the judge to look at. Now, the judge probably will adopt one of them because judges aren't going to go through and create parenting plans for every case that come through their courtroom. But now in mediation, for example, you've raised a number of times that I appreciate the example about dividing the Christmas holiday. And that does come up on a pretty regular basis. Who are the kids going to spend Christmas Eve with, Christmas Day with, and how do we alternate that? What does it look like? And the Christmas break, if it's 2 weeks, how do we divide that up? Do we subtract Christmas Eve and Christmas Day out of it so we divide the rest of it? It can get very, very nuanced and very complicated. And you want the time to kind of sort that out with the discussion if they haven't done it in advance. One lawyer that I've done a number of mediations with, and I really appreciate the work they put into it, sends out a parenting plan to the other side well in advance of the mediation so that they can commence discussions about the parenting time, vacations and holidays well in advance of the mediation. Because if you don't, and you want to spend time during the mediation doing that, you can spend a lot of time talking about it. There can be some disagreement, and you may end up using a lot of time. It may be far more efficient to try to resolve as much of that as you can prior to the mediation by having the litigants and or lawyers exchanging those kinds of ideas ahead of time. And if you've got issues like substance abuse, domestic violence, you're well advised to anticipate and consider what kind of parenting plan you want in advance, because it's going to run into some very rough water during a mediation. If you've got a DV victim being asked to agree to a 50-50 parenting time, and it's probably not going to go anywhere. So practice and discussion in advance of the mediation is well advised, because those are the kind of things that just sometimes won't get resolved. So I would say also be prepared when you go to mediation if you've got an issue like that, or any other issue, business evaluation, anything that's of high conflict that you know might not get resolved. Be sure and talk with your client about, well, do we want to resolve the rest of this stuff and come to a partial agreement so we can carve that out and then just focus on, for example, decision making and parenting time at the trial. And you can then use your 3 hours to more fully and completely address issues that the judge probably should have even spent more time talking about. But at least you'll get your day in court on those very important issues relating to children.
You know, one of the things while you were talking, I kind of came to my mind again. I'm going to throw you a little curveball because we didn't talk about this one either. But what about the parent who wants more parenting time to lower child support? Because in Arizona, we base our child support on parenting time and income. And so if you have more parenting time, you pay less child support typically if you're the payer. And there's some people who really just want the lower child support, not necessarily the more parenting time. And there might be the parent who doesn't care as much about the child support, but really, really wants the parenting time. And so in Arizona, we have to fill out a child support worksheet. And that child support worksheet is based on the number of days each parent has, the income each parent has, and some other items there. In mediation, you've now gained the opportunity to really find out what's driving each parent. And you don't have that opportunity really in court, right?
Yeah, you raise a great point. As a side note, I would just note that Launi's background in this probably, at least in part, flows from a case she had in front of me about 13 or 14 years ago when this precise issue came up. And it's been a source of discussion over the years. I do believe that that can happen on occasion. And you have far more time to talk about that in a mediation than you'll ever get at trial. And the risk at trial is the judge will move to the conclusion that that's what asking more parenting time is all about, to reduce child support. And if it's not, you certainly don't want to be caught in 10 minutes left in your trial trying to persuade the judge that the reason you want 50-50 parenting time has nothing to do with reducing your child support, but that you want more parenting time. And that, as Launi knows from personal experience, can be a difficult situation.
Well, yeah, and there's also that, like in most cases, in my cases, it was the mom who really didn't necessarily need the child support, but really wanted the parenting time. And maybe the dad who doesn't really want the parenting time, but doesn't want to be out of pocket all these expenses. And so in mediation, you can fill out maybe 2 sheets and you kind of go, all right, where's the difference? If you had everything that you wanted, the parenting time you wanted, if the court was going to give you every number that you put down here as correct, and then the next parent does the same thing, makes their child support worksheet with all the numbers that they want, there's an opportunity for the judge to just pick one of those. But the judge does have a little more ability to sort of pick and choose what numbers they want to put in each block.
Right.
But if it comes down to somebody's numbers equal $500 and somebody's numbers equal $550, then you're talking about $50 a month. And you can either split the difference. You can say, yeah, I didn't realize it wasn't such a big deal. But knowing those numbers in mediation, you can go, let's split the difference. And you can't do that in court.
No, absolutely right. I mean, in those situations, they're a little easier. Where it gets more difficult is that if the one parent who wants to have more parenting time has historically been exercising the kind of parenting time that would result, just by way of example, in a payment of $1,300 a month in child support, and then the new 50-50 parenting time reduces it to $278 a month, that's where things can really grind to a halt, and you really get into a dispute over what the parenting time should be. And you're right, you do have the opportunity then to do some creative math with both the child support and also to determine whether it's about money. Because if the one parent would agree that they'll continue paying the $1,200, even if they get 50-50 and the other parent refuses to, you've got a different kind of problem. And oftentimes if somebody says, look, I want 50-50 parenting time, I'll keep paying you $1,000 a month. That should resolve a case that if nothing else is the problem, and it's about money, that should do it. Another kind of alternative I've used is if there's a marital residence that's going to be sold or refinanced, is to come up with a lump sum of child support that would be waived, but brought out of the equity in the refinance or the sale of the home. For example, okay, we'll reduce the child support to $278 a month, but the $900 equates to about $10,000 in a year. And so for the first year, I would like you to prepay, and we'll agree to do the 278. And the person will agree to pay 10,000 out of their share of the equity of the home, or the refinance, and the money issue goes away. So you're really focused on getting rid of the money issue as the reason that's stopping the parents from agreeing on a parenting time.
And really another great creative way to do it, to get something resolved that just cannot be done in court.
Right. No, yeah, there's no way that the judge would ever have the authority to do that, or would consider it. I mean, you have to remember, when judges get done with the trial and the gavel comes down and they go into their chambers, they've got 60 days to get that decision out. And they've got all kinds of cases. It's like a waterfall. It just never stops. So the next day they know they're coming back to court, and they've got maybe 2 trials, maybe pro se trials that are 90 minutes or an hour. They've got to keep the decisions coming out. So the judges are not back there being as creative as people can be during mediation. They don't have time for it, and they won't do it. So that's why, again, mediation is important, and the pretrial statement. If you're going to get creative, that's your last shot if you're going into the courtroom.
Now, Steve, give me a couple, maybe an example or two of why you would not want to mediate. Like, what case is not really the best suited for mediation?
Well, that's a great question. I mean, and I have seen and participated in mediations where lawyers will start accusing the other lawyer on the other side of never having had a good faith intent to mediate the case, because they're just so far apart on asset numbers, or they're so far apart on parenting time or legal decision making that the accusations start pretty quickly. But those are the cases where I see sometimes if you've got domestic violence, if you've got significant substance abuse that endangers a child, and the other side is not being realistic in terms of agreeing to maybe benchmarks to alleviate a parent's concern. For example, being involved with their own therapist, having a mental health professional participating in the case, so that they can send reports to either the court, or they meet certain benchmarks to satisfy the other parent that they're participating in alcohol or substance abuse programs, batterer intervention programs. They're participating in counseling. And as they reach those benchmarks, they then can move forward to a parenting plan. If you've got a parent that says, no, there's nothing wrong with me, I'm not going to do that, and it's pretty clear that they are not going to settle for anything less than joint legal decision making, and you do not think that's in either the litigant's best interest or the child's best interest, then you need to really think about, do you want to go to mediation and do that? If you do, I would say be pretty strict on capping the amount of time you want to spend. The same thing comes with, I've had cases recently, the parenting coordinator, where a 17-year-old or 16-year-old was involved in the case, and the parents were at rather significant odds on whether to continue the joint legal decision-making and joint parenting time. And the kid hadn't been over to one of the parents' house in months, and had no intentions of going there. The one parent wanted to go to mediation. The other one said, no, let's just get the kids interviewed and decide what to do then. So there are sometimes you've got, yellow flags that are waving around that you want to parse out the issues and limit your mediation to defined issues. Or if, sometimes people say, look, this is a global settlement. We either settle everything or we don't settle anything. So you've got to talk with your lawyer or decide what you want to do. And if it's global and it's all or nothing, and there's no way you're going to settle one of those issues, don't waste your time and money going to mediation. It'll just get people more entrenched in their position. So those parenting time issues oftentimes are the things that either break down mediations or they get carved out and go to trial. The rest of the stuff generally can get resolved. The other big stumbling block I see sometimes are business evaluations and where the money went with a business. Those things can be problematic because it's either I won't carve it out, it's got to be global, or they're willing to carve it out. So my question is, why didn't we carve that out ahead of time and reduce this mediation to 2 hours instead of spending 3.5 and finding out we're not going to get anywhere on the business evaluation? So it just takes some thinking about what are your goals in mediation? Is it a global settlement? And if it's not global, nothing? Or are you willing to carve some things out and then decide whether you want to carve it out immediately and not even talk about it, or reserve that issue, get everything else settled, and say, okay, now let's turn to this issue. And you can find out pretty quickly whether you're going to have any movement on it. But yeah, domestic violence can be a real showstopper.
One of the things when you're talking about domestic violence, I love that you brought that up, because what's really great now, I very much disliked having in-person mediations when I was representing a victim of domestic violence, especially if there weren't safeguards available. I was always very big on making sure there were safeguards available, that we either did it at the court, depending on the significance of the domestic violence. And now with Zoom, these two people don't ever have to even see each other. They don't have to be in the same room. Certainly, look, when I've seen my clients who are victims of domestic violence see their ex for the first time going to court, and they kind of throw up a little bit in their throat, right? And they're very anxious, they're very sick. It's something that they hadn't expected. And we always try, and if there's a way to get that first view out of the way before I try and do that. But in mediation, you don't have to do that, right? You put people in different rooms. So talk about that.
Well, you raise a great issue again. I mean, with the advent of Zoom, if you are representing a domestic violence victim, you really should strongly consider letting the mediator know we're appearing by Zoom, period. Because if you don't, and you go to a private, a lawyer's office, very few of these take place at the courthouse. They can, but assuming that you're going to a lawyer's office with your client, there's always the possibility that the victim is going to run into the abuser, going to use the restroom, going or coming to the mediation, and you have to plan for the victim's arrival. You certainly don't want your victim meeting you there at the office and then parking the car and coming into the office because of the potential of running into the abuser. So you've got to plan for the arrival. You have to plan for the departure. And you can't just let the victim leave the lawyer's office and go out and go home. That doesn't work. Can create a very dangerous situation. So yeah, if you're representing a DV victim, it takes some real thought, and certainly the ability to appear now by Zoom. I would strongly urge a lawyer to let the victim, one, stay home, because it's probably stressful for them, or stay wherever they want to and not necessarily come to the lawyer's office. That's one of the beauties of conveniences of Zoom. You can be in a separate room with your client talking to them, and they're at their home where they'll feel comfortable, safe, and secure. So that's something that I think should be of prime importance and consideration for a lawyer if you're representing a DV or an abused spouse, or a spouse where it's clear to you there's not a level playing field in trying to negotiate what's going on in the case. Any type of intimidation, whether the lawyer thinks, well, you shouldn't be intimidated by him, there's nothing, well, that's not your call. So you have to be very careful with that. And that's why I really appreciate the safety and convenience of Zoom, particularly in those kind of cases.
And for those of you who don't know, Zoom has a way of, you can open up other rooms. So you can put, when Steve does his mediations, he can put a lawyer and their client in one room, and then a lawyer and another client in another room, and they don't ever have to see each other. They would never hear each other. They are completely separate. And then Steve goes back and forth between rooms. Now, he could also set up a third room where he goes and talks to just the lawyers if the lawyers are, say, like at home or at their office when the other party's at home, to where he can talk to just them. But there is the opportunity with Zoom to have separate rooms so that you never have to see them. So it's not like you're seeing me and Steve here right now, where we'd have everybody in there. There are separate rooms, so you could have, the 2 people plus Steve, and then the 2 people plus Steve. Or if they're unrepresented, then just, the spouse is in separate rooms, and then Steve would go back and forth.
Yeah, great point, Lonnie. And I have had several cases where the lawyers have contacted me prior to the commencement of the mediation and said, look, my client doesn't want to see or hear from the other litigant. It would be very traumatic, and we don't want that to happen. And I say, thank you for the heads up. That's not a problem. And we conduct it exactly as you've just pointed out. The lawyer and the client go directly into the room and never see or hear from the other side at all. And I just go back and forth to the rooms as if we were in a physical location and moving back and forth between the caucusing rooms.
Well, Steve, thank you so much for being on the podcast. I really appreciate it. I know it's not your favorite thing to do, but thank you so much. I do appreciate it. Is there anything that you'd like to add?
No, I think you're doing a great job on these. I really appreciate it. And thank you for the invitation. You had to twist my arm a little bit, but I'm glad I did it. And
so just so everyone knows, I will be putting Steve's contact information, his website, in the below the podcast and the YouTube videos. So if you are trying to get a hold of Steve, you can reach him at his website. Thank you, Steve.
All right. Thank you, Lonnie. Have a great day.
You too.